Well, good afternoon, everyone. Thank you so much for joining us this afternoon. I'm really excited today for a great presentation that I'm sure everyone can find true value in. My name is Stephanie Anderson. I am the Industry Operations Manager for the National Apartment Association. I also have the pleasure of being the staff liaison for the Independent Owners Committee. We thought today was a great topic that so many people can relate to and need advice in. And so before we get started, just a couple of housekeeping items. Today's webinar will be recorded. So if you are unable to attend all of today, or you want to go back and share this with someone later, or even take a refresher, we will have this available in the next week on our website for independent rental owners. That's located at naahq.org. In addition, we will also be taking questions and answers towards the end of the presentation should time allow. If you will click on the box, you'll be able to see a Q&A box. Please feel free to type in any questions that you have for our presenters today, and we'll try to save those to the end in hopes that they're able to answer those throughout their presentation, and we'll circle back around at the end if time allows to be able to take some Q&A. Well, without any further ado, I would love to get started. Today's topic is Don't Get Eaten by Sharks, Litigation Avoidance and Management Strategies. Today, we are joined by Lynn Dover and Rick Snyder, and I would love to go ahead and turn it over to them. Welcome.
Thank you. I'm Lynn Dover, and I'm the managing partner of the Fair Housing Practice Group at Kimball, Tyree, and St. John. We're a statewide law firm. I've been practicing in the rental housing industry my entire career, which is 30 plus years. I think Rick's been around even longer than that. Rick, you want to give a little background about yourself?
So I first came into the industry in the mid-70s, so it's been quite a number of years. My management company operates in the western states, primarily in California, but I've been extensively involved in the real estate industry in management and specifically with the National Apartment Association, and I'm the incoming secretary for NAA. But in addition to my involvement from an industry perspective, I'm also extensively involved as an expert witness, providing testimony relating to real estate standard of care, and most particularly within the management arena.
Next slide, please. Stephanie, next slide, please. Thanks. So we want to start by giving you a little bit of an overview on some current and emerging litigation exposure areas and kind of what the legal climate is. Habitability in rental housing continues to be a big issue, not only in defense of evictions, but also as a separate lawsuit. And Rick, you want to talk a little bit about some experience that you have with that in terms of the litigation climate?
Given that both Lynn and I are in California, unfortunately, we tend to be the bellwether for issues that, if they're not already in your area of the country, are most likely to migrate there. And we do apologize in advance for that happening. But we're finding that habitability lawsuits arising from physical conditions in the apartment that plaintiffs are alleging are substandard conditions are taking a forefront in terms of litigation against both owners of multifamily apartment communities as well as their management companies. And what we're starting to see is that a tenant will complain about a condition in their unit, and they'll contact a plaintiff's attorney, and the plaintiff's attorney will advise their client, the resident of the complex, to communicate with other residents in the same property and enlist those other residents in attempting to get a larger group of individuals to file a lawsuit against the property and the management company. And as a part of these habitability lawsuits, what we're starting to see is that through the guidance with the attorneys, these tenants are making complaints to the building department or health and safety related complaints, building what we experience as a record to show that there's deficiencies both in terms of the condition as well as the response by the management company. And so these issues really are taking a significant issue and confronting property managers.
And I think that tagging on to that is the next topic, which is environmental issues, which can also play into habitability issues. And the top ones that we're tending to see are mold. Some of you may have been around long enough to remember when mold wasn't toxic, but sometime in, around the late 1990s or early part of the century, suddenly we have toxic mold. And I know that we have defended as a law firm a lot of mold complaints. And then lead and asbestos for your older buildings. Lead paint is particularly an issue, to my understanding, on the East Coast, more so than on the West Coast, although we still have a presumption that a building that was built before, I believe it's 1973, has lead. And similarly, buildings built before 1981 are presumed to have asbestos. A lot of the issues that we see in our law firm center around a failure to properly remediate. And then, of course, we've got the whole bed bug issue that has come to the forefront. Back before DDT was banned as a pesticide, bed bugs had been eradicated in the United States, but they have made a strong comeback. And particularly with the influx of people from other countries and the fact that there's so much travel and that bed bugs hitchhike, we've seen that come back into play. Rick, what's your experience been with these issues?
All of these issues, what we're defining as environmental issues, continue to be a major component of the habitability allegations from residents through litigation. And characterized in both of in these areas, both habitability and environmental issues, are two components that are the major thrust. Did the owner or manager have notice of these adverse conditions? As Lynn indicated, was there a proper remediation, which is, was the response from the management company to these noticed conditions both reasonable and timely? And that becomes the measurement, the frame of reference for assessing whether or not the issue was properly responded to. And one note that I should make regarding asbestos, it used to be that at a specific time and place, I believe, as you said, Lynn, it was 1981, that if the property was built after that period of time, that asbestos was deemed to not be present. Unfortunately, now many local air pollution control districts are taking the position that the wall surface, if it is going to be disturbed, or a ceiling, or even a floor, that because materials are coming from outside of the United States and are not being tested, that the requirement is to test for asbestos, and if it's a pre-1973 building, for lead, prior to any work being done in the property. And so this has become a significant issue for management companies on dealing with physical conditions within their premises.
So the next topic is fair housing, and that's where I spend the majority of my practice these days. And the hot topic in fair housing has been and continues to be disability, and specifically reasonable accommodations and modifications. Rick mentioned that being out here in California, we tend to be the forerunners on things that are happening. We have some new fair employment and housing regulations that go into effect on January 1st, and they will only govern the state of California, but oftentimes when things happen in California, that's where they happen first, and they do spread to the rest of the United States. So the new regulations that are going into effect for us spend a lot of time talking about reasonable accommodations and modifications. And what we're seeing is that residents are becoming more and more aware of their rights in terms of fair housing, and particularly with regard to disability. We're also seeing that tenants' rights groups and legal aid and other such organizations are finding new and creative ways to use the reasonable accommodation process to delay evictions, keep somebody in their housing even when we've already had an order from the sheriff to lock them out. We spend, I would say, at least 90% of our time in my department helping clients deal with reasonable accommodation and modifications issues. At the top of that list seems to be assistive animals, and particularly companion animals or emotional support animals. I think when somebody has a service animal, for example, if you have a resident that has an obvious vision impairment and they've got a dog that's obviously a guide dog, nobody's going to question that. Everybody understands it. Everybody gets it. Everybody, agrees that it's necessary to make exceptions to a no pet policy or perhaps a breed restriction policy to allow that person to have their service animal. Emotional support and companion animals are a little bit different because it looks like a pet. And a lot of times what we're finding is that, residents are able to get documentation from their doctors or even from online service providers such as online LCSWs that verify that they have some sort of a emotional or mental disability and that they need to have this animal. It's become all too easy for them to obtain these types of documents. And a lot of our clients are complaining that their no pet properties have turned into pet properties as a result, or that when they allow pets, but they require a pet deposit or pet rent, that people are using this as a way to get around having to pay pet deposits and pet rent. Unfortunately, if the person has provided adequate documentation telling them that they can't have the animal, leaves you open for a fair housing complaint. And fair housing complaints can be really time consuming and expensive to defend, even if you ultimately win. You're going to spend a lot of time and a lot of money defending that complaint. So our goal is always to help our clients stay out of fair housing trouble. But we also do have, a defense wing in case somebody files a fair housing complaint. Rick, do you have anything to add about the fair housing issues?
One of the issues that has come up over the last, in the last decade has been a policy called disparate impact. And it's where there is no overt discrimination, but there is a policy or a procedure that is put in place by the management company that may have a differential impact on, as an example, families with children. So one of the recommendations that I would make to any of the participants listening is to look at your lease agreement, look at your rules and regulations, look at those with a view specifically as to whether or not you've got policies specifically relating to children, and be concerned about the context of disparate impact. And what the recommendation that we're providing is that the lease and the rules and regulations, because of the significant changes that are going on in the management industry for residential properties, is to look at those, the lease and the rules and regulations, and look to change them consistent with current law and the fair housing requirements on an annual basis. It's a very good preventative step to avoid exposure in this area.
It's a very good point, Rick. I'm going to defer to you on employment because I have no involvement in that, and I'm sure you have a lot of experience.
Yeah, and unfortunately, in my company, we've got about 250 employees, and so this has become a significant issue. And we'll talk about this a little bit later. We sometimes, with some chagrin, talk about that our employment attorney that we work with is somebody that we have their number memorized and can call readily, because the area of employment law and its application from the commencement of employment to during the course of employment, having an employment handbook and then termination of employment is increasingly becoming an exposure area for property management. And the problem is that it was, from an industry perspective, not something that, at least in my experience, management companies were focused in on. Because of the litigation that has come out of this particular area, we've had to focus in on them. And it's not just employment, it's workers' compensation, it's the manner in which you handle incidents that occur, it's regarding workplace safety, harassment, all of the things that you can think of that will impact on employment is attended in this area. And from my perspective, based on what we anticipate, this is an area that all of us need to continue to be diligent in and continue to maintain our focus on.
Thank you, Rick. Stephanie, next slide, please. Okay, so one of the things that we like to talk about is practicing what we call preventive law. Preventive law is kind of like preventive medicine. It's not a guarantee that you're not going to end up in legal entanglements, but it helps you to try to avoid them. And if you do end up in a legal entanglement, to be able to prove that you didn't do anything wrong. So the key, the number one key to that, from my perspective, is documentation, documentation, documentation. The more you document something when it happened, or very close in time to when it happened, the more likely it is, number one, that it's going to be a memory tool for you, but even more important, that you're going to be able to convince a judge or a jury or a fair housing investigator that your version of what happened is the correct version. Imagine yourself for a moment as a judge. You've got two people in front of you, or two sides in front of you, and they're telling completely different versions of the same story. How do you figure out who's telling the truth? It's not that easy. Well, now what if one of those sides, for everything that they say, they've got documentation to back it up? You've just made that judge's job a lot easier. Any comments on that, Rick?
Uh, what I often, just to support what Lynn just mentioned, is it's so important to create and maintain a communication log. And what we often talk about in a litigation context is a contemporaneous writing and the power that that has, because it's not trying to reconstruct the events. It is a note, a communication, a documentation of that communication in real time, and it makes all the difference.
Agreed. And then written policies and procedures are equally important. A lot of times something will come down to, what's your policy on that? Or what's your normal procedure on that? And was it followed? And this kind of tracks with the next bullet point, which is also consistency. This is particularly crucial in a discrimination case, because you may need to prove that, number one, you were following your written policies and procedures, and number two, that you were consistent, that you were treating everybody the same, and that you weren't discriminating or showing a preference, because you can be tagged for discrimination for showing a preference based on some protected class as much as you can for discriminating against a protected class. So consistency in your documentation, in applying your written policies and procedures, is absolutely critical. Rick, any comments?
And one caveat that I would provide, or warning, as it relates to your written policies and procedures, we have a context or a concept that views our conduct as a property manager, as a real estate professional, which is called the real estate standard of care. And in this case, it would be the property management standard of care. It's important that you're knowledgeable about what that standard of care is, number one, and that that standard of care is the basis by which the written policies and procedures are created. One of the problem areas that I often see is that a company will go, this is my term, overboard in their policies and procedures, and will create a level or an expectation of policies and procedures that, candidly, through the day-to-day operation of the property, is just not realistic. The problem that the management company finds themselves in, even though those policies and procedures are above the standard of care from a general view, um, the plaintiff's attorney is going to hold that management company to the requirement of those policies and procedures, even though they're above the standard of care. So again, what I would recommend very strongly is to ensure that those policies and procedures are realistic, reasonable, and that they're being implemented and followed by your staff that is implementing those policies and procedures at the property level.
So our next one is get advice early when you see trouble brewing. Boy, I can't stress this enough. It's so easy, particularly for on-site staff, to want to try to avoid spending money on legal fees, which we completely understand, and to continue trying to handle a situation when really they're in over their head and should at a minimum be looking to their supervisor or to the owner of the company, if that's who they report to get some advice, and certainly to looking to legal counsel as well. It's easy to make a mistake and do or say something that you shouldn't have done, but once that bell has been rung, you can't unring the bell. You can't go back and say, whoops, never mind, didn't mean to say that. It's always okay to tell a resident or an applicant, you know what, let me check into that and I'll get back to you. There's nothing wrong with that answer, particularly when it's a tricky situation, such as a fair housing or an employment situation. If you're dealing with an employee, it's okay to tell them, I need to look into that. I need to talk to my supervisor. I need to check with legal counsel, and I'll get back to you. As long as you get back to them within a reasonable period of time, you're good. And then limiting attorney's fees provision in your lease. Now, I'm going to use California as an example. Here in California, we have a law that says that attorney's fees are reciprocal. In other words, even if you have a clause in your lease that says, if I, the landlord, win, I get my attorney's fees, the courts interpret that to be a reciprocal provision. Most contracts do have reciprocal language. The prevailing party gets their attorney's fees. What I can tell you is that oftentimes the other side's lawyers charge a lot more than your lawyer may. So if you lose the case, you can be on the hook for a significant amount of attorney's fees. So it's becoming more common to put a limitation on that. For example, in an eviction case out here in California, we think that a reasonable limitation might be attorney's fees and costs not to exceed $1,000. That way, if you lose, that's the most you're on the hook for. Rick, any thoughts on that?
It has definitely, that is the custom and practice in the industry here in California. And going back to the trouble brewing bullet point, I want to make the point that I think many of us that are drawn to this industry are problem solvers. We like to initiate action and to solve those problems. Consistent with what Lynn was recommending, create a culture within your company that encourages collaboration, where you're getting a supervisor or other individuals that can provide input into providing alternatives or a strategy that is going to meet the needs of whatever the situation is that is brewing. It's very, very important not to operate in isolation, but work collaboratively with your coworkers.
Thank you, Rick. Stephanie, next slide, please. Okay, so dispute resolution, I'm going to let Rick take the lead on this because he's kind of an expert at it.
Yeah, so unfortunately or fortunately, this is many times what I deal with, because this is before it gets to litigation. And many times when I find that a resident who is unhappy about a situation, they have a very difficult time articulating what the issue is. And so I've got a process that I take them through to encourage them to identify what the issue is, because many times what they want to focus in on is what I call the story. And so I say to them, I can't solve your problem unless you allow me to identify what the real issue is. And once I get them to help define the issue, then I go through a process with them of effectively communicating. Sometimes that means creating some boundaries with that resident. Many times, my experience is with tenants that are feeling that they're at the effect of a situation that is going on, it translates into them being very, very angry, and they'll raise their voice. Um, Two things that I use as an effective means of being able to counter that is to ask them to allow me to speak and let me just speak uninterrupted. If they continue to raise their voice, I'll speak slower and lower my voice. And it has the effect of not continuing the escalation of the communication, but rather de-escalating the communication so that we can again then refocus on defining the issue. And then what I find, because people through their anger find that they feel and experience that they are not empowered to have choices or have an effect on whatever that negative situation is. So what I seek to be able to do is to provide the resident with options and choices so that they can help define what the solution is. So that if you have, going back to one of the earlier issues relating to habitability or environmental issues, where you have to do work, I'll give the tenant the option of terminating their lease, providing back their full deposit, putting them up a hotel, providing them with a rent credit during that period of time, living in the premises while we're working on one of the bathrooms as an example, but I give them those choices. And then once they've identified what their choice is, then that final bullet comes into play, which is to document not only the options and choices that you provided, helping to define what the issue is, and this is again effectively communicating, and then documenting what their choice is. When you put those elements and you go through that in kind of a linear line, it makes all the difference, because you can turn a bad situation into a situation that the tenant experiences that the management company is not only acknowledging what the problem was, but effectively resolving the problem to the satisfaction of the tenant. And you actually, instead of just having a tenant that's angry about us, you turn them into someone who can be a cheerleader for your community.
Thank you, Rick. And I'll just tag on to that and say that there are times, and Rick, I'm sure you've experienced this, when none of that works and none of the options that you provide are satisfactory to the resident. They just want to be angry and complain. And sometimes they just are in a litigation mode where they want to sue you. So going through this process and then documenting it thoroughly can really help if it does escalate and we do have to get to that next level to show that, as Rick mentioned at the beginning, that you operated and communicated and did everything in a reasonable manner, as a reasonable owner or manager would in a similar or same situation.
Exactly right.
Next slide, Stephanie. Okay, so receiving a letter from an attorney, sometimes that can cause what I like to call a knee-jerk reaction. A lot of times a letter from an attorney can be very inflammatory, very accusatory. And if you're the person who is on the receiving end of that, and you know darn well in your own mind that you didn't do or say the things that you're accused of doing, it can be easy to have that knee-jerk reaction and fire back. That's exactly what you don't want to do. So the first thing you want to do is do promptly contact your own attorney. You want to try to get an early resolution and avoid a lawsuit. And having your attorney handle the response can keep the emotions out of it. That's one of the things that we do as attorneys. Is our job is to listen to our clients, gather the facts, and provide a non-emotional response. I like to say kill them with kindness, because we're going to be firm and we're going to be tough in the sense that we're not going to just roll over and take what's being hurled at us, but we're going to keep our emotions out of it, try to calm the situation, and try to get to an early resolution. We don't want you to contact the attorney who wrote the letter because you can unintentionally make the situation worse. Rick, thoughts?
One of the dynamic changes that has occurred in the last number of years is that we used to have interaction with the complaining resident that would occur prior to receiving a letter from an attorney. Unfortunately, that environment is changing. It's not been unusual in today's environment to receive a letter from an attorney without any contact or any notice of any adverse condition in the apartment. That goes true also for the receipt of a lawsuit. One of the elements that we don't have as an item on this list is that some insurance companies are taking the position that you need to notify your property insurance coverage if you have an indication of a lawsuit. Some insurance companies have taken the position that if you receive a letter from an attorney regarding a potential lawsuit, or where the attorney is asking for insurance information, that there's a requirement for maintaining coverage from your property's insurance to have that notification go to your insurance policy. Even though you're not going to submit a claim at that point, you're providing notification relating to the contact so that there's no question that you can ultimately be able to pursue coverage on the insurance policy. But don't contact the attorney that has sent you the letter.
Yeah,
That's
it's
the
just,
underscored issue.
yeah, just not a good idea. Next slide, Stephanie. Okay, so now you've been sued. And the first question is, should you try to settle or should you try to litigate? You know, settlement considerations, I spend a lot of time talking to clients about the value of settlement versus the value of litigation. And oftentimes, again, emotions come into play and people feel like, I didn't do what I was accused of doing. Why should I settle? The number one reason would be avoiding the time and expense of litigation. As I mentioned earlier when I was talking about fair housing, and this applies to any type of a lawsuit, you're going to spend a lot of time litigating. You're going to spend a lot of money on your own attorney's fees just defending the case. Sometimes you're going to end up spending more money on attorney's fees than the settlement amount that's being asked for. So just avoiding the time and expense of litigation can be very valuable. The other thing is you have a certain outcome. When you go before a judge or a jury, you're putting the case and the decision in the hands of someone else. And as an attorney, and I used to do litigation before I joined this firm and went into the fair housing world. I used to go to court all the time. I used to litigate. We can have the best case in the world. I can make the best arguments in the world. The other side can have a crummy case. And ultimately, we could end up losing the case just by reason of who's sitting on the bench that day, or if it's a jury trial, the makeup of the jury. So when you go to court, you don't have the certainty of an outcome. You could end up losing even with a very good case. And then there's the avoidance of bad press. And Rick, I'm going to kind of turn it over to you at this point to talk about those first two bullet points, but also to hit on that bad press issue.
You know, when they used to talk about resolving an issue takes two, getting into a conflict takes two. The attorney that is handling the case on behalf of the plaintiff really is the driver as to whether or not the plaintiff is going to seek to settle the case or not. There's many landlord-tenant plaintiff firms that are basically a lawsuit mill. And my experience is that those types of attorneys are not interested in an early settlement. And in fact, their initial demand is for sometimes hundreds of thousands of dollars, well overstating what the value of the case is, only to, after some level of discovery, of having it limited down to a number that potentially the parties can settle. Um, that sometimes requires some discovery process, which includes production of documents, what's called interrogatories, where there's questions asked and a response required, but also a deposition of the plaintiff in order for both the plaintiff's attorney and your defense attorney and yourself to really have an understanding as to the merits of the case. And it's been my experience that it's at that juncture in time that substantive settlement discussions prior to any further discovery or prior to the case going to trial is when the most opportune time or opportunity exists.
Thanks, Rick. You want to talk a little bit about avoiding bad press and the potential negative impact on the owner's relationships with their clients, or the property company's relationships with their clients, and the relationships with the residents?
The bad press really comes, at least in my experience, not arising out of a single plaintiff, but where a group of residents, especially if they go on a rent strike or they go to the media and they get some traction with the media, that bad press is going to be an issue. But what the litigation considerations about the potential negative impact on the client relationships and the resident relationships really does become problematic. The residents do talk to one another. As it relates to the client relationships, and just a caution that I would urge anyone thinking about this area, have a good indemnity clause in the management agreement. It is absolutely imperative that that language is appropriate and provides protection. The indemnity provision that I use in my contract is written in a way in which um, the owner and the management company in a fee management situation are standing shoulder to shoulder, being responsive to the allegations that are being presented by the plaintiff. The intent is that rather than the errors and omissions insurance by the management company taking the responsibility of representation in the litigation, it's the property's insurance that is going to be providing representation both for the landlord and tenant. But having that clarity in the management agreement is really your first step in dealing effectively when you are sued, so that there is clarity that that property's insurance is going to cover both parties, both the owner as well as the management company.
Thanks, Rick. And I just want to tag on, this is something that isn't on our slide, but it's becoming more and more of an issue. And Rick, I'm sure you've had experience with this, is the negative online reviews. It's so easy when somebody's angry for them to go on Yelp and similar sites and just really slam you as a property manager or an owner. I know that a lot of our clients are hiring firms that deal in reputation management, that can deal with these online negative reviews and you know, kind of put a stop to it before it gets out of hand. Any thoughts on that, Rick?
It really does make a difference. We're much like restaurants and hotels and other service providers. Um, the online reviews are now taking a front position in a potential tenant's review and decision as to whether or not they're going to live at our communities. And so reputation management arising out of litigation, but in the general operation of the properties is becoming a significant issue for all of us.
Thank you, Rick. Next slide, Stephanie. Okay, so when you get served with a lawsuit, the first thing you want to do is contact your insurance company and your attorney. Rick mentioned earlier that there may be some obligation to contact your insurance company before you've even been served with a lawsuit when there's anticipation of a lawsuit. But certainly when you get a lawsuit, you want to promptly tender that to your insurance company and your attorney. There are time limits to respond to a lawsuit, and it varies from state to state, and even within a state varies depending on the type of a lawsuit. But it usually isn't more than 30 days at the outside. What you don't want to do is sit on it until day 29 or the last day to respond, whatever that time limit is, and then suddenly contact your attorney. We may be able to get a continuance to respond, or we may not. So you're putting yourself at a disadvantage right out of the gate by not contacting your attorney promptly so that the attorney can start working on the next necessary step. You don't want to try to represent yourself. There's an old saying that a person who represents themselves has a fool for a lawyer and a fool for a client. Just don't go there. Even us attorneys don't represent ourselves. If we are, then we've got a fool for an attorney and a fool for a client. Rick, any thoughts on this slide?
Every time that you get served with a lawsuit, you go into shock and your heart starts pounding, the adrenaline starts running. And for some people, depending on their personalities, you don't want to have to deal with it. Consistent with what Lynn just said, that's the worst thing you can do. What you need to do is recognize that this has helped me in many situations and in observing defendants in other cases, treat this as a business issue. Don't take it personally. The lawsuit and what their allegations are do not have to have any power over you. You just need to treat it like you would any other business issue that you have before yourself and your company. Don't avoid it. Deal effectively and efficiently with it. And you do that by contacting the insurance company and or your attorney. Now, one thing that, for those of you who have not had a lawsuit before, many times when you notify the insurance company, they will have attorneys that they work with, and they will direct who that representing attorney is, who's going to respond to the lawsuit from the initial receipt of the lawsuit. And even in today's environment, the official service, and Lynn, I'd like you to just tag into this, doesn't occur until you're actually served, correct?
Correct.
And so it's many of the attorneys that are attuned to what's going on, and they may have your names, could contact you and say, I see that you've been sued, and you haven't even received it yet. You've not been served. The date of service doesn't occur until you've been sued. But if you know the lawsuit is out there and somebody who contacts you gives you information about that lawsuit, that gives you a head start on being able to talk to your own attorney and being able to contact the insurance company, and you want to do both.
And I'll just tag on to that and say that, as Rick said, a lot of times insurance companies have their own attorneys that they work with for defense of different types of cases, and ultimately that case may be assigned to that attorney. But if you have your own attorney, go ahead and contact them, because sometimes there can be a little bit of a lag or a delay, in the insurance company picking up the defense and getting you hooked up with that attorney. So if you contact your attorney right out of the gate, even if they ultimately don't end up with the case, they can start making steps, such as if there's an extension that needs to be asked for, getting on that. So don't just sit back and wait for the insurance company to tender the defense and get their own attorney involved. If you've got your own attorneys, do go ahead and contact them. They can help even if they don't end up with the case.
Agreed.
Next slide, please. All right, so demystifying the litigation process. As Rick said, if you haven't been sued yet, you haven't gone through the process, it can be a very mystifying process. It can be a very stressful process. One of the things that happens, and Rick talked a little bit about this, is pretrial discovery. And that often takes the form of interrogatories, which are questions that you have to answer, or questions that your attorney propounds to the other side, to the plaintiff side. Requests for admissions, where the goal is to get the other side to admit that either something happened or something didn't happen. Request for production of documents. This is where keeping good records really comes into play, because if you're asked to produce documents by the other side, your attorney is going to send that request to you, and you're going to have to come up with those documents. So if you've kept good records and you've kept them in good chronological order, that should be an easy and speedy process. Whereas if you hadn't, it can be challenging. And then depositions are where the other side's attorney gets to sit down and ask you questions in the presence of your attorney and a court reporter. Rick, you want to weigh in a little bit on the practical aspects of those things?
I should mention that litigation, as someone who's a defendant in litigation, redefines non-productive time, unfortunately, because you're not making money out of this process, and it diminishes your focus from what you otherwise should be focused in on. But you're compelled, given the circumstances, to get involved in this. I often think about pretrial discovery in the context, if anybody is listening that plays poker, much like each of the cards coming out from the cards that you're holding either strengthens or weakens the respective party's case in the litigation. So as interrogatories and requests for admissions, especially requests for production of documents, and then finally, and most importantly, deposition testimony, will either strengthen the plaintiff's case or weaken their case, and conversely the same with the defendants. And so as you go through it, the settlement negotiations that can emanate out of that for each of the respective parties is either improved or diminished. And that's why settlement negotiations often occur after the pretrial discovery is completed or in process, because the parties are attempting to discern what their strengths and weaknesses are and what that dollar number for settlement should be.
Thank you, Rick. Then when we get to preparing for trial, I know back when I was doing trials, my trials were limited to eviction trials, so they tended to be fairly what we call short cause matters. Usually, we're able to complete the trial in a day or less. In terms of gathering documents, I used to tell my clients, bring me everything. Bring me your entire file on this tenancy. We'll go through it together, and I'll pick out the documents that are relevant to this case. What I didn't want was for the client to do that themselves, because you don't always know what's going to be relevant and what's not, whereas your attorney knows what documents are going to be relevant to the case, and also what is evidence and what's not evidence. And just an example of this is in an eviction case, it's very common for a complaining resident, let's say that it's an eviction based on behavior, where the person that you're trying to get off the property is accused of engaging in some really egregious or bad behavior, or just throwing lots of loud parties, disturbing their neighbors. The neighbors often don't want to come and testify. And while we could subpoena them, they're probably not going to make very good witnesses if they don't want to be there and they're afraid of retaliation from that particular resident. So then the next thing is, did we get the complaint in writing? Well, the complaint in writing is not admissible as evidence to prove what happened. It's considered hearsay evidence, and that means that the person who wrote the document is not there for cross-examination. But that doesn't mean that we can't use it as a business record to show that the manager received X number of complaints and that the manager was acting as a reasonable or owner or manager would under like and similar circumstances. So what I would say about preparing for trial from an attorney's standpoint is, do let your attorney take the lead and let them tell you what it is that they need and what's going to be admissible and what's going to be relevant to the case. Because there may be things that you think are not relevant that actually are relevant, and vice versa. Things that you think are relevant that actually aren't relevant within the parameters of that particular case.
And preparing for the trial is something, going back to one of the issues that we talked about earlier of the contemporaneous writing. And that provides that record, if you will. And what you have to recognize of when you get to trial, especially if it's a jury trial, is that ultimately you want to be able to provide a frame of reference for the jury to assess the testimony and the documents that evidence what occurred in this case. I often find that the creation of a timeline so that the jury has a context of who did what to whom and at what juncture in time, and again, getting back to the reasonableness of the response by the management company, becomes critical, along with visual aids, photographs of different issues, depending on the nature of the issues in the case, all become important, because what you want to do is to have elements that the jury can have a reasonable reliance upon those objective facts to render a decision that ultimately and beneficially should be to your favor in the litigation.
And creation of a timeline is also very helpful to us as attorneys. The earlier you can get something like that to us in the process, the easier it makes our job. It saves us from having to wade through a lot of documentation and create our own timeline. It's helpful to have that timeline with the documentation to support it. In terms of what to expect at trial, most courts favor resolution before trial. So even if you have had settlement discussions that have broken down, most courts are going to either have a mandatory settlement conference in advance of trial or sometimes on the day of trial, or for a shorter cause matter such as an eviction, they may send the parties out into the hallway to try and see if they can reach a settlement. Just because settlement discussions were not productive earlier doesn't mean that they won't be productive at that stage. Sometimes that's when the settlement occurs. Oftentimes, at least out here in California, the settlement conference will occur in the judge's chambers, and the judge will have the plaintiff and their lawyer come back first. They'll have a discussion, then they'll bring the defense and their lawyers back. And their goal is to try to get a resolution because, as I mentioned, once it goes before a judge or a jury, the outcome is out of your hands. Courts also favor resolution because the courts tend to be clogged, and if they can get a case resolved and not have to have a courtroom clogged up with a trial that may take, a day, 2 days, a week, or more, depending on the nature of the case, that's good for everyone. If the case is unable to be resolved, then the best advice I can give you from an attorney's perspective is to follow your attorney's lead. Listen carefully to the questions that are being asked by your attorney and also by the other side's attorney on cross-examination, and only answer what's asked of you. Do not volunteer information. Do not go further than the question that's being asked. And the reason for that is you can unintentionally say something that makes your position less favorable. So listen carefully to the question. If you didn't understand or didn't hear the question, it's okay to have it repeated, to ask for it to be repeated, but don't volunteer information. Rick?
And what I would say, if you took 100 cases that the lawsuits are filed, the ones that actually go to trial out of 100 is 2 to 3. The vast majority of cases are going to settle. If you think that you're going to be proven right, that you're going to find justice for your position, litigation and a trial is not the means by which that's accomplished. It just isn't. To the degree possible, keep your emotions out of the equation. You'll find, based on your perception, that people will get on the stand and lie. They're not going to tell the truth, even though they've just taken a sworn statement saying that they're going to tell the truth and only the truth. again, this is sometimes about perceptions, but sometimes people just do not tell the truth. Keep your emotions out of it. Be principled, but don't attempt to exert a principle upon the other side. That's why one of the things that they talk about in settlement is that in a good mediation, both parties come away not happy with the total outcome, but they've got it resolved. And it is important that you're there, but it's important also that you don't show facial expressions that is going to negatively affect the jury. Allow the process to move through the stages that it needs to go through to come to a conclusion.
Thank you, Rick. Stephanie, next slide. Okay, I
I
think
think
we're
just
done. So
questions.
yeah, questions and answers.
Well, great. We are just right on schedule with time too. So thanks everyone. We have gotten one question so far. So I'm going to go ahead and read that. But for those of us attending the webinar today, there is a Q&A box. Please feel free to go ahead and type in any questions that you have for Lynn and Rick. And as long as time allows, we'll answer all that we receive. So we received a question from Jody. Jody is an owner manager of 3 rental units. Currently, they document conversations, repairs, mileage, etc. on both Word and Excel documents, which can be quite inconvenient and inefficient. Jody is looking for any suggestions, possibly an app that would be better suited for documenting these items.
So most of the more sophisticated software, property management software systems have an ability to have these recorded interactions placed in the tenant file. For smaller property operations, such as just was described, not to promote a specific company, but it's one that is often used by many companies that have a smaller portfolio of properties, is a company called Appfolio. And they have a lot of the sophisticated elements. It is reasonably priced and will give you that type of communication ability and recording of communications, whether it's maintenance work or communications with the tenants, in a very easy format. And that's what many of the larger companies use that a company like Appfolio can provide.
Great, thank you. We just received another question from Albert. And Albert would like to know, where are the best places to find the changing standard of care?
From your local association is one source. From a state association or the National Apartment Association will provide you with an indication of what that standard of care is. A firm like Kimball, Tyree, and St. John provides white papers, legal Q&As on various subjects. All of those are very good sources of information that help to provide the standard of care. When you look at the various educational course offerings that are available in the arena of property management, like in California and most states have continuing education course offerings, some of which are specifically oriented to property management. Those property management materials help to articulate and confirm the standard of care, that by taking those classes, you'll be more knowledgeable about what that standard of care is.
Thank you. We have another question from an anonymous attendee. They would like to know if requiring mediation as a condition of the lease for resolving non-rent breaches of the lease or other specific circumstances, if that would be a good consideration.
Well, I think it depends on the law in your state. You know, some states may have a law requiring mediation or against a requirement of mediation. So I think the first thing there is to look to your attorney in your particular state to see if there are any laws that govern it at all. If there are not, what are your thoughts on that, Rick? Mandatory.
In most of California, you can't create a mandatory requirement for mediation, to my knowledge.
Mhm.
And I don't know what the rest of the states are, but generally speaking, mandatory mediation is not a part of most lease agreements, to my knowledge.
Yeah. And I'm not sure that it, if there's no law that says one way or another, I'm not sure that it is all that productive, because mediation, as opposed to arbitration, where you've usually have some type of a decision, mediation is just that. And early in the game, if the parties aren't inclined, one party or the other is not inclined to, to resolve, you may just be wasting time. What are your thoughts about that, Rick?
Yeah, many times it's just not productive if both parties in good faith are seeking to mediate the issue. So I agree totally.
Well, I would like to take this moment to thank you, Lynn, and thank you, Rick, for your time today. You gave so much wonderful information. Just a reminder for all of our attendees today, this has been recorded and will be uploaded to our IRO webpage at naahq.org for you to view in the next week. Thank you again so much for everyone who's attended, and we look forward to seeing you all again on the next webinar.